Chapter 3, Part 2. The court structure and jurisdiction are kind of dry. The court process may be even more dry. But let's go through it. We're going to go through the court process, and then we'll go through the appellate court process, and just kind of get a feel for what the procedures are and how many steps you have to go through in a court of law. And the question we're looking at in this one is, what is discovery, and how does electronic discovery differ from traditional discovery? So here we go. Okay, the court process. Step 1, pleadings. These are written documents that are brought before the court with each side's claims, and the primary pleadings are, and they're literally called pleadings. This is what starts the process off. What is the complaint set forth by the plaintiff? Okay. Once that's been filed, there'll be a summons from the court to the defendant, and they will have to answer. They have an obligation to answer it. If they don't show up or they don't respond, then there'll be a default judgment, which usually goes for the plaintiff. So it's very important, if you receive court papers, to respond and find out what's going on, and to be sure to show up. Now, your answer, you respond, okay? And you assert affirmative defenses, reasons why this is not true, or they're limited. And then you could also, at this point, assert counterclaims, which, you both could have valid a disagreement or disputes between you. So this is where you would put all of that on the table. If the defendant asserts a counterclaim, then the plaintiff has the right to reply to that counterclaim. So you can see how this is all very, very measured and back and forth. You're trying to set the stage for what the hearing or the trial will be entail. Then, after all of this is taken care of and settled, you have what they call pretrial motions. And a motion is a request for relief from the court prior to the disposition of it. You could have a motion to dismiss. You could actually motion for a judgment on just the information that's been given to the judge or the court at that time from the pleadings above. And the court can grant this motion if there are no disputed facts in it. Otherwise, you could go for a motion for a summary judgment and discovery to the date and we'll get into discovery here in a minute. And again, if there's no disputed facts, it's fairly cut and dry. The trial may never go to trial, and it may go down in pretrial motions. And now we come to step 3. And step 3 is the discovery part of a trial, of any trial. And that's where both sides try to get as much factual information as they possibly can about what is involved in this. There will be depositions, which are sworn testimony. It's recorded by a court reporter. Sometimes they're videotaped. They're taken prior to the trial, and they're often used to obtain testimony from a witness or somebody who cannot either attend or be compelled to attend or testify at the trial. So you'll have depositions, you'll have interrogations, written questions that must be answered under oath. You can have requests for admissions, and these are questions to the party phrased in an admit or a deny format. There's no opportunity for an explanation. It's just a yes or a no type situation. There's requests for production, which are including requests for documents, electronic documents, things of, anything pertaining to the trial or to the matter at hand. You can ask for all the documents involved. And you can have a request for examination, which is you can ask to have somebody examined to see if they're physically able to stand trial or if they're mentally able to stand trial. You hear this many times in criminal cases. And that is the discovery, and this is both sides. They're both trying to get as much information as they possibly can and get it out on the table. And sometimes in discovery, enough will come out that both parties will say we probably should settle now and go before the judge. There's one other part of discovery, which is the electronic discovery right here. And that's where an expert is hired to retrieve electronic data, and that's becoming more and more the case anymore. Software is used to reconstruct the communication. Deleted files can actually be recovered. And sometimes, many times, you can find a smoking gun that you can't find with the typical type of discovery we do up here. And it's very time-consuming and very expensive, but many more people are doing this. More trials are being brought out with electronic discovery, especially if it's a criminal trial of the white-collar nature. Right? White-collar, such as in white-collar crime. And we seem to have corporations will have electronic discovery much more often. Step 4 is pretrial matters, is what they call it. You can have a pretrial conference where the court will schedule one or more conferences just to resolve any procedural matters or to narrow the issues. It's sort of like, okay, we are going to court, so let's sit down and talk about this. If there's any more motions that can be brought out, this is where you will have them settled. To decide if the trial is going to have a jury or without a jury. If you have a trial without a jury, it's called a bench trial. In a jury trial, it's just kind of interesting. If you have a bench trial, the judge is the arbitrator of all the questions of fact and law. When you have a jury trial, the judge just worries about questions of the law, and the jury worries about questions of fact. So, all of this is really very, very structured in how it plays out. And then you have jury selection. And that in of itself is quite a procedure, especially if it's a high profile. So 12 jurors are selected, and I think we have 2 alternatives selected. And once you get to that point, then you're ready for Step 5, which is trial and post-trial motions. The motions ask the court to dispose of the parties' claims. You can ask for a direct verdict. You can ask for a motion for a judgment notwithstanding the verdict. You can ask for a motion for a new trial if you feel that the trial there's been an error of some sort. So it is very, very structured in how a trial plays out. If the losing party is unsuccessful, and obviously it is, if it's the losing party, it is unsuccessful, they can ask for, post-trial motions, and they can end up, going and saying, we're going to appeal this, because it didn't come out the way that we think it should, or this wasn't looked at, or maybe part of that trial didn't go the way we wanted it to, or maybe there was a breach of the law in that trial. So there are many things that can happen, and once you get to this point, then you've got the judgment. It's based on the jury's verdict, and you say, no, I'm not going for that. I'm going to appeal. So then you will come down, and you can file an appeal, and you can ask the appellate court to view it. So there'll be a notice of the appeal. There'll be evidence of your intent to appeal. The record and transcript of the pleadings, motions, hearings of the trial will be sent to the court. There'll be briefs sent with the legal arguments supporting the appellant's request. And they usually, an appellate court generally, does not or will not rule on questions of fact. Okay, unless the evidence is just so overwhelming that you just can't absolutely ignore it at all. Okay, so usually the appellate court is going to look at how the court, the previous session went through, and did they follow the law? Was there anything out of hand for that? So after all of this is done, the appeal, the notice of the appeal, the records and all the information being transferred, briefs, that lay out what's going on, then we get to the appellate review. And there may be an oral argument, or there just simply may be a review of all the information, the transcripts, and all that went on in the previous trial, depending on the nature of it. And after all of that is reviewed, then, one of three things it looks like can happen. They can affirm it and say that the court's judgment was correct, or the ruling. They can reverse it in whole or in part, and then remand the case for further proceedings in trial court, or they can reverse the trial's decision and render a judgment at that point. So in one case they reverse the decision but say there has to be more trial or more discussion. In the other one they reverse it and they give a judgment right there without further court proceedings. Now if they lose in the appellate court at the state level, or at this intermediate level here, they can go on to the Supreme Court, and that would be at the state level. Again, the state Supreme Court does not have to hear the case. It has a choice of accepting it or not accepting it. So this is a very lengthy process, as you can see, and can take many months and sometimes years. It's going to take me years just scrolling up. First you have the pleadings. Then you have pretrial motions. Then you have discovery. Then you have pretrial matters. And then you'll have the trial, and you'll have post-trial motions. Now, in between all of that, you'll also have jury selection, which can be rather lengthy. After all of that, you can still appeal it into the appellate court. If the appellate court does not render what you would like, you can request going to the Supreme Court for a decision from them. And again, the Supreme Court, the state Supreme Court has to be accepted. It's not a given. So that's a very lengthy process that we're going to go through. Here's a question. True or false? Discovery is a process of obtaining information before the trial from both parties. The information can be in hard or electronic copy. True or false? One small bit of more information just to throw into this is the court systems at this point in time is they're lagging in the technology area, which is somewhat why things move so slowly. I mean, there's a lot of hard copy going on there. But they are starting to come into the technology age. There is some electronic filing going on right now. There's some electronic posting. Some of the courts are posting what's going on in the court. And there are some cyber courts. Now, there are not many of them, but there's just a little bit of experimentation going on with them. I think once this takes off a little bit more, it may speed up the court system. But our court system is very slow, as witnessed even with the trials, criminal trials. They can take years, and in most cases, they do take several years to get things to the point where you could say that they have been settled, and then many times there are more appeals. So our next part 3 is about alternative ways to settle disputes, which makes a whole lot more sense. So let's move on to that one.